morning, and I just want to express my gratitude for being invited here on behalf of the American Civil Liberties Union and my affiliate, the New York Civil Liberties Union, to participate in this important conference. And I'm humbled to be here in South Africa on the 20th anniversary of democracy, by the struggles of the people of South Africa for democracy and the amazing work of Legal Aid of South Africa. It's truly an honor to be part of the conversation with you. The ACLU is not a legal aid provider. We are a totally independent NGO that defends basic civil rights and civil liberties. And the New York Civil Liberties Union is one of 50 branches of the ACLU that represents people in the state of New York. We don't take government money. We rely on our almost 50,000 members in New York to provide us with the funds that we need to do our work. It's been interesting for me to hear so many references at the conference to the landmark United States Supreme Court case, Gideon versus Wainwright. And it's important, I think, to note that while the United States, which is clearly a place that has a fairly well-developed system of legal aid and access to justice, it was only 50 years ago that we recognized that the principle enshrined in our Constitution over 200 years ago of the right to a fair trial did not encompass a right to government-funded legal aid until 50 years ago. And it's also important for us to acknowledge in the United States that while we may have 50 years of experience providing the right to counsel in criminal cases, we still have a lot of problems, a lot. In New York City, my colleague Seymour James told you about a pretty well-developed system of providing legal aid services, and it is a model. But what's also true in New York City is that the way legal aid became such a good model was in part because of experience, but I started out my legal career at Legal Aid. That was 5 years ago. Okay, 40. And we had a union of the lawyers who work at Legal Aid. And my first year at Legal Aid, we went on strike. We didn't go on strike for higher wages. We went on strike for the right to represent our clients effectively, for lower caseloads, for the right to investigate our cases, and the right to follow our cases and our clients throughout the entire process. So they didn't have a different lawyer every time they went to court. I think that's important to understand. Also, New York City is one place, but New York State has 50 different legal aid systems because every county provides legal representation in its own way. And it's kind of nuts, and it's also quite ineffective. So for about 30 years, it's been acknowledged that our system statewide of providing legal services is profoundly flawed. We have no set of minimum standards for who can provide criminal defense services. We have no statewide oversight of what's going on in the provision of legal services, even though the responsibility rests with the state to provide legal representation for people who are wrongly accused, not just wrongly. And we've had disastrous results. So people in Syracuse, for example, will appear before court charged with a serious felony without ever having spoken to a lawyer. And what that means is the decision, the all-important decision about bail is set without the benefit of a lawyer. So people have bail set on them on a shoplifting charge, on minor offenses, People negotiate with the prosecutor themselves or with the judge about a plea and take pleas to felonies when the accusations are only a minor offense. People end up losing their licenses, their professional licenses to work, because if you're guilty of a felony, then you can't work, for example, as a nurse. People's families are destroyed, disrupted for minor things, and because they don't have a lawyer to stand up for them every moment of the criminal process. So, what do we do if we don't represent individuals in criminal cases? Well, we look at the whole picture, and we filed a class action lawsuit against the state of New York 7 years ago, challenging the failure of the state to have minimum standards, to have oversight and training of the lawyers and the system of legal representation. We're in court now. It's taken us 7 years. We've won some great decisions, but we have yet to accomplish the reform. One of the lessons of our experience in New York is that, as we say about civil liberties in general, the fight for civil liberties, the fight for human rights never stays won. There are new challenges every day, and we have to fight for the right to provide legal aid in our communities constantly. Because if it's not about money, it's about a government that today doesn't care about defendants and about people wrongly going to jail. If it's not about, in the states, there's a lot of funding for prosecution, but very, very little concern about defense services. So we have to fight constantly and employ the legal tools that we have. We have to rely on the direct service providers to give us the information about what's going on every day in the courts, to collect. We have to insist on getting the data that we need to identify patterns and problems, bring major lawsuits to challenge the problems, but we also have to engage in a campaign to win the hearts and minds of the public, so that the public understands that it is in their interest, in every way, shape, or form, economically and also morally, to provide adequate legal defense. And we do that by telling stories of what happens when we fail, and we do that by looking to the politicians and trying to convince them, and indeed pressure them, to respect the fundamental rights that are outlined in the UN principles. Thank you.